Wake up, America. Don't divorce. Okay, maybe you have to. Your kids will suffer, but if you must, the empirical data is in. Every study imaginable supports that a divorcing couple will increase the mental health of their children when they mediate rather than litigate. So heed our warning, do not hire a lawyer whose interests are about their family and their children. You know, save your children. I have with me an expert mediator, JD, Marty Gofberg, and he's going to help me and help us through what we can do to help ourselves from this entirely disruptive event that can happen to you in court. So let's get right on with this, Marty. I haven't talked to you in a while. What I'd like to do a little bit differently than what we usually do is speak to the audience like they've never heard of anything about what's important about the children's lives going forward, so that they don't litigate their child's lives away. So let's get it started. What do you think the basic thing they could benefit from by mediating rather than litigating?
Well, one of the first important points is that the least represented party in a divorce between a man and a wife or two partners that are going through that process is the child, because the child is not physically there. And what the court is relying on is what's the best interest of the child, but yet they really don't have any acknowledgement.
So right up front, the most important thing is missing.
Right. They don't have the acknowledgement of who the child is, what their likes, dislikes, what their schedule is like in terms of visitation or, scheduling, custody, and all those kinds of issues.
Personal needs, nothing.
They have nothing. So the least represented person in a mediation is the child or children.
Yeah. Let's talk about the representation aspect to mediation. There's going to be a learning curve here, so for the audience. So going backwards from where we were when we first started, one of the first things we learned is that we don't really take charge. We're facilitating. So maybe they should understand what a neutral third party does.
Most people are used to conflict resolution, and they think of it, where conflict resolution is anywhere from negotiation to war. and divorce is unlike a lot of things, but it's very similar to war.
Right.
Because you have two parties that have taken positions, become entrenched in their positions. Once they hire attorneys, they become even more entrenched in their positions, and they don't even get a chance to speak because the attorneys tell them not to speak to each other. So now you have any lack of communication about anything that's going on between the two parties, least of all the children.
I always thought that was funny. The people that need to talk the most are held apart.
Right, and so everything is done through attorneys, so it has nothing to do but escalate the levels of conflict that already exist.
And the person that's representing you assists you in the elevation of the
that's their job. Their job is to do what's in the best interest of their client and to zealously advocate and any way they can speak for their clients.
Right. It's a terrible shame that we allow that to happen, but we don't have much choice. Now, one of the reasons why we don't have choice, the audience should know that in our state, unlike many other states that have either mandatory mediation or have a mediation program where you can voluntarily involve yourself in our state we have the judiciary keeping us away primarily, but it's also whatever the New York State politicians decide to do, they've kept mediation out of the box.
But people do have a choice. People can access mediation, and that is something they need to learn about in terms of where they can access mediation. How do they access mediation? Now, a lot has happened with the New York laws in terms of having, actual no fault in New York, which is the first time in decades.
What does that do for them?
Essentially, the parties can, divorce without going through a full-scale trial, without alleging all kinds of allegations. In the past, they had to, You have
to sign a 6-month agreement, right? That you've been apart for 6 months, or that you've had irreconcilable differences.
Right, they're amicable or agree to part because, oddly enough, there are irreconcilable differences.
Right.
So they're essentially agreeing to agree to split and work the paperwork that route.
Is there anything in the court system that would keep a couple together if they were marginal confronters of being aggravated or to accelerated anger or
one of the things
less acrimonious?
The litigation process itself can take anywhere from 3 to 5 years sometimes, so they're still effectively married. they're still effectively dealing with, the children in a marriage. And so, it exacerbates
Right.
the conflict. And, one of the things about mediation is that it works rapidly, quickly, expeditiously, all those words,
Right.
to effectively cut down on the conflict, to get the parties to actually talk to each other. Now, the parties can have lawyers, at the mediation to use as references and to, have them there to guide them through the legal process.
If
But-
they should so choose.
Right.
I mean, mediators act differently in that regard. I don't particularly care for the lawyers to be inside the room. I think they disrupt the process too much. Let's talk a little bit.
And also, it's important that the parties actually speak to each other.
Right.
Because through the mediator, who does not make any decisions, but really the only tool the mediator has is questions, is being able to find out what the parties' views, are as to all the various different issues that they put on the table.
I find it hard to explain to people the mediation process because it is unique. One of the things that occurs to me that I'd like you to expound on is we're not really telling anyone to do anything. There seems to be some need to have us to take a judge's type of role, where we find it's not a neutral third
Right,
position.
we're encouraging self-determination. In other words,
that's a way to explain it. Good.
Right, we're able to encourage the parties to effectively resolve their dispute in ways that they know will work for them, that will schedule for them in terms of
Right.
the custody between the husband and the wife or the partners. And
up front, Marty, what's more important than the self-determination? If you're trying to come to a resolution, what's more important? Hardly anything, and that's very important to be able to determine how your life is going to go going forward.
And
here's
one
your
would
opportunity.
think, that's
Yeah.
one of the least thought of aspects of litigation.
Exactly.
Is that they're not really thinking prospectively how is going to, this process going to unfold years from now.
What do you think happened there that caused the people, because we're talking about an audience that's not aware of mediation, that caused the people to think that litigation was the only option, or that battling, or that confronting, or the adversarial process was the only place you could go to? Where did we come from?
Well, it's tradition. I mean, like I said, people, once they're in conflict, they assume they're at war and they want to basically destroy each other and generally have a winner and a loser. And the only process that accommodates that, short of war,
You mean-
in this country is litigation.
You mean
We're
because you're
civilized war.
angry, Marty? You mean because you're angry that the only thing you can do is win your argument, and that's the thought? I'm trying to figure out what's going on in the mindset of the people. I know the time I got divorced, I didn't think to have to fight with somebody. So let's sit down and work something out. And my ex-wife decided that she had to go get somebody to protect their interest. It caused a lot of problems after that, and that's what everybody finds out. I don't know. We don't have to know. The audience doesn't have to know what causes it, but it's there. You're going
Right.
to find yourself in the place where you're deciding that.
Well, and society said the first thing to do is sue. So, and the first
Sue
place where
consciousness.
you have legitimatized war is in litigation, in the court process.
Right.
And that's where you can go to war in this society. So it's natural for them to take their dispute where they can, commence war against each other, as opposed
Yeah.
to a process that allows them, through their own ability to self-determine what it is that they want going forward prospectively, and be able to make an agreement and all the
Communicate.
parenting plan and all the things that go along with a divorce.
Let's go a little further into self determination, because I think that if we can get the people as a mediator, if we can get the couple who's about ready to separate and not be a part of one another to understand that because they're angry, this is the key problem I have sometimes, that they're so angry at one another that acquiring the knowledge that they can self-determine to them sometimes mean I'm going to get my way. That's not what that is really. We want them to get their way. We want them to communicate together to facilitate the best response for that family, right?
Right, and that usually is done by questioning both parties and being able to have both parties act reasonably, towards one another. And in terms of, when you're doing the mediation, you find out things about the couple that a judge would not be able to do, because what I like to do in initial mediation is to learn about the couple and find out what initially brought them together.
And one of the things you do is right in front of you, this is a picture of your daughter. Andy, if you can get that shot in at this time. I would say that is something I do as well. I put the picture of their children in front of them so that they have to look at those kids every time they make a decision. It causes them to think more proactively about what to do going forward.
And it also, as a mediator, tells me sometimes, because what I like to do is I encourage parties to do that, to bring a picture of their favorite picture of the child to the mediation. I spend some time at the initial session explaining that, and that they are the least represented typically in this process, and they need to be brought in. And obviously we can't bring minors into the room, or it doesn't fit with people's schedule, and it would be inappropriate to have minors in a mediation. But if you bring their pictures, we're going to say that they're there with us,
right?
And they're looking at us, and would they want us to see each other arguing and getting hostile with each other, or would they rather see us working out our differences,
right? And
as civilized people, and more importantly, as parents?
That's the most intelligent thing you can do to a child, is to allow them to see their parents, if you're going to separate, if they're going to be divorced, to see that they're proactively working on an agreement that causes them to work something out, to see them in communication and in agreement rather than in anger or in disagreement.
But it also brings up a lot of issues when you ask a couple to bring their favorite picture.
Yes,
I very use that word, favorite, because I expect people to bring in, like this, a framed picture, one that usually is in their living room or den or bedroom, and so that that they're it's a warm memory for them. It's a treasure for them.
I see.
And so it's important for me to see how both parties act, in terms of, I had people that make photocopies of a picture and have it all crumbled in with a bag, and you have people that bring in old pictures,
whatever,
and just put it down on the table. And I said, you have to explain again, I would like your favorite picture so it could stand up like this, and you can actually have the child looking at you on the mediation table. Because I do face those pictures towards the parties.
Yeah, I'm working on that.
But it also tells you, sometimes if they bring a family picture, you try to go back and use that to see, well, you were in better place and time, and that particular picture, what made you go to being hostile? So you can find out sometimes in a mediation, what you cannot do in a court is what actually caused the hostility.
This isn't necessarily psychoanalysis, but it is a...
No, you do not practice
no, but it's a form...
any kind of counseling or...
Excuse me, it's a form of discovery. I don't use that legal term, discovery. I mean, discovering about the couple.
Right. But the point is that it opens up a lot more information for me as a mediator to find out, what do they have in common? What do you have an interest?
Where can we find
to
common
pull back
grounds?
On when they get into conflict, to go back, well, do you remember the time when you were, first met and you were romancing each other? And you can go back to that and try to get them to go back to those emotions, and sometimes it works, sometimes it doesn't. It's, and that's the beauty of mediation. It may not work for everyone, but for those couples that really want to resolve things in a peaceful and calm kind of way, it's probably the best process, because a court cannot go through that.
Do you ever find that in a mediation session that the couple has looked at or contemplated or received services from a lawyer before they reached you? You found...
Sometimes.
You've seen that, right?
Sometimes.
Me too. Well, what does that work for you or not work for you? I found it go both ways. I don't know. I have to fight back a lot of negative information.
It could be a double-edged sword sometimes, because sometimes lawyers, being zealous advocates for their clients, do not want their clients talking freely in a mediation. They don't want to disclose everything, maybe from the financial aspect to other aspects of the mediation in terms of personal information. But usually, I find that I try limiting the attorneys at a mediation and just use them as the parties' resources. So in other words, I'm letting the parties negotiate themselves, but every time the lawyer steps in, I say, well, this is the parties' process, which means, the two mediating parties.
It takes
Whether it be the husband and wife, or a partner and a partner, or even in a commercial aspect, you have two businesses.
Right.
Whatever the parties want, sometimes it is more important for them to hear than it is for the attorneys, but the attorneys are always there as a resource. So the more I can keep the parties talking,
right.
it usually works out better for the parties.
Right. I feel the same way. It's the confusion that can develop is more of a concern for me than maybe what does or doesn't happen. But I find the resources when it comes to protecting the client aspect, or this is how the law is, or this is what you can do and this is what you can't do, I find that it's hard for me to beat that back down.
What's interesting, though, is that the next generation of lawyers coming up have been trained in the law schools, like in our local Truro Law School, are being taught how to be advocates in mediation, and realizing that it's not a litigation,
I
and
thought
that they can serve the best interest of their clients without obstructing the mediation process.
Oh, that's interesting. I had heard that they were training in mediation. I didn't know that particular aspect was...
Yes, they in fact have a course, how to be an advocate in mediation at Truro.
Well, that's good.
And Shiva University Law School also, I believe, they have that same kind of a program. But now they have negotiation and mediation competitions in the law schools, which is nationwide.
Wow.
So you now have a nationwide group of lawyers and starting to understand the mediation process.
We have to do a program on that when we get a chance to, all right? When you come back and do that program. A little bit further about the audience not knowing what this is about, what mediation process is about. Can you try to go through the 1, 2, 3 of how a mediation session works without having it be a lengthy process? The introduction of the couple. It's different we should point out that it's different for all mediators. Mediators handle it differently. Licensing is not there yet for us, but won't be much longer before that probably does happen, which is a concern for some and not a concern for others.
That's very difficult. That's a whole show.
Yeah, I know. That's something. I'm not sure I want to get in that right now. Yeah.
But basically, how the process works is you allow each party to have an opening statement. And sometimes when I have represented counsel there, I'd much rather have, the parties speak after the lawyers. I'll let one lawyer go and another lawyer go, and then have both parties speak, each giving their opening statement. And if I have any questions, then I will usually ask them after each is finished. Not one at a time, but usually by grouping. And then what I will then do is explain that the lawyers are there as a reference and as an expert in the law, and that I would encourage the parties to work with the mediator to try to resolve the situation by...
Let's assume that the lawyers are not in the room, it's just a couple. Sometimes there's dead silence, am I right?
Right. Sometimes the lawyers take affront to that, but then again, they are there as the parties' counsel. So they're there to advise them as to the law. They're not there as a party.
Let's assume that the lawyers are not in the room, that they don't have lawyers with them. They're the couple is by themselves. After the introduction, as you explained,
right,
the
they
opening
both have an opening statement.
Right. Then you go toward conversation that they develop on their own, or do you suggest a beginning point? What do you want to do? I always talk about the children first.
Yeah, well, in that context, I asked them if there are any children.
Yeah.
Then I explained to them to the next session, if they didn't already have been told, to bring a picture, of their children. Usually that's not the case. Usually it's for, the first session, I really want to get to know the couple.
Yeah.
And to be able to understand, as parties, where they're coming from.
See, because the audience is unfamiliar with this relatively developing business of mediation, relatively new in New York anyway, all these things are possible. And because all things are possible, you have to have an open mind for that. I don't mean you have to have an open mind, it helps. Otherwise, it'll take a few more sessions. But what we're really trying to do is we're trying to expose the fact that you can develop, you can self-determine by knowing some of these things, by knowing that you can talk about your children. You can talk about your children first. You can get rid of your anger first.
I mean, it helps, with that in getting to talk with the couple initially to be able to understand what the issues are. And the mediator in his head can develop a mediation plan.
They tend to tell you what the issues are.
That have sprung out from the opening statements, and then it's my actually to be quite frank, I actually missed my opening statement. Generally, the opening statement for the mediator is before the parties or counsel even talk, explaining what the process is, and that each party is going to be asked to give an opening statement. That the mediator is there not to make any decisions, but to mediate between the parties. So it's really important that that the process be opened up, and the only way you can do that is by learning about the couple in order to move on.
Right.
So
it's a problem-solving session.
Right. It's it's a session to get to know what the parties are like, what issues are hot button issues, what issues are not, to know where they're at in terms of.
And the audience is sitting there going, okay, so that's something you have to do. But if I'm angry at my significant other, how am I ever going to get to this point?
Well, sometimes it might be that mediation may not be a process that's appropriate, and if there's no connection between the mediator and the parties, then right then and there has to be some simpatico for the process to work. So that might not be the proper mediator, or the mediator may not be appropriate for those particular parties.
I try, that's always a thought of mine too, as I go through the process. Am I the right or not? I don't think about me being the right one. I assume I'm the right one, but I might not be the right one. So there may be some other feeling that they have about the situation. I need to be sensitive to that. Right,
and it's very important that they trust you as the mediator. So you need to be able to do that. The only way people can trust you is for them to know a little bit about you. So when you're going forth in terms of questioning the parties, you try to bring up a conversation that is mutual all the way around between all the parties at the table, so that you can develop some trust and confidence.
And what Marty's doing right now is he's talking about some of the things that happen in a more broader sense, but they're absolutely what we do. We talk about the openness of something rather than the absolutes of something, and we facilitate rather than determine. Right? Those
everything's finite, and then you water it down.
Yeah.
And then you filter it down to what works.
Yeah, the couple has to tell us as mediators what's going on, so that we can help funnel or narrow down the focus to help them go forward more.
Right, and keeping in mind that all those answers are coming from the parties, not the mediator.
Right.
I mean, that's the overall arching theme that people looking for mediation need to understand, is that they're the ones that are going to ultimately be making the decision.
And that's hard for them to grasp, and that's another thing I wanted to talk about today too. How do we get to it? How do we get them there? Is not always a 1, 2, 3 type of thing for us. Like when you're in court, there's a 1, 2, 3 about it. You sit here, you wait till you're being told what to do. This process is going to go on here, and you lose your self-determination, as you said before. So if you're going to lose the self-determination, you're in court. If you want to be able to help to see what's going on going forward with your family, then you'd consider mediation, right? Is that a major difference?
And one way I really know, if you're really a true mediator, a real good mediator, those mediators are exhausted after the session, because the mediators make it look easy,
right? Because
they're not, they're not advocating anything, but at the same time, their mind is going 150 miles an hour of what questions, what what body language are the parties giving in order to be able to think of the next question, or what issue should be brought up, how should it be brought up, which way should it be brought up, which party A or party B.
I don't know about you, Marty, but have you ever made a mistake? I mean, I have.
Oh, everyone does.
Yeah, I mean you head off in a certain direction because you get to feel the couple's ready for something, and you say, well, what about this? And they seem not to be been ready for that, like the extended.
You find out very quickly.
Yes, and right where you're at.
And that's why you need to be tuned in to the communication process. And overall, sometimes when I really get to know the parties, and you really understand what the issues are, and how they came about to being there, and you realize sometimes it's not even a legal issue.
Right.
You know, it's just a miscommunication or perceived disrespect.
Okay, you got
of one party to another.
You got 1 minute to go through the benefits for children, all right? Because what's some of the benefits that come to your mind? You got 1 minute.
Well, the whole point is that, you know, within the mediation process allows both parents to be able to structure a custody situation and timing, visitation, all that fits their schedules.
Determine.
As opposed to a court that doesn't even know what their schedules are. And that way, you know, by mediating it, they're able to do what they want in their lives,
right,
as opposed to being court ordered to do something.
Right. In court, you're paying for the access to get them to determine. In mediation, you're paying lesser amount to get access to your own life and to your own determinations. Thank you very much, Marty Gofberg. I appreciate that. Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every single week. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.